Good afternoon. Welcome to this afternoon's lecture on the Khashoggi assassination and whether does international law matter. Our speaker today is Stephen Rattner, who's a Bruno Simma Collegiate Professor of Law at the University of Michigan Law School. And I was intrigued and I wanted to invite Professor Rattner here after I came across several articles he wrote on this very issue for the US blog Lawfare, and also more recently in an article for the Washington Post. And I think you were quoted quite a lot at the time by ABC News and others. Professor Rattner is well placed to give our talk today. He's not just a scholar of law; he's also practiced law for the US government. For the State Department in the 1980s. He's also served on expert panels for the UN Secretary General addressing post-conflict justice in Cambodia and also in Sri Lanka. And his most recent book is titled The Thin Justice of International Law, A Moral Reckoning of the Law of Nations, which was published by Oxford University Press a few years ago. And if you want to know more about Professor Rattner, you can have a look at his bio online.
So just 5 months ago, nearly to this day, on the 2nd of October, 2018, Jamal Khashoggi, Saudi journalist, insider, outsider, commentator on Saudi affairs, disappeared after entering the Saudi Consulate in Istanbul for some routine paperwork before his marriage. In a world where state summary executions and disappearances of political opponents are still quite common, Khashoggi's murder has become the paradigmatic international incident. While media accounts focus on the political ramifications for Saudi Arabia's relations with the West, the episode has far deeper implications for the future of some of the core constitutive norms of the international system. In my remarks today, I'd like to reach beyond the conventional analysis of the Khashoggi assassination and explore the incident from the perspective of international law. International law offers a set of agreed norms and frameworks for analyzing the murder of Khashoggi in a way that people around the world, whatever their political motivations, ought to be able to agree upon. The law and its mechanisms for enforcement frame, influence, and constrain state policy and the responses of states to one another's policies. But international law is not simply a set of diktats from above that govern state behavior. The mechanisms and modalities for enforcing international law vary immensely, from strong state sanctions and even international courts to address some rules, trade, investment, human rights, law of the sea, to very weak mechanisms to respond to others like international humanitarian law. As a result, episodes like the Khashoggi assassination offer a test of the law's adequacy and indeed relevance. The law is shaped by these events just as much as it shapes them. Now, the idea of looking at international incidents as a test for the state of the law is not mine. In a wonderful book published 30 years ago called International Incidents, The Law That Counts in World Politics, to which I contributed a chapter, the editor, Michael Reisman, wrote, "If law is to be found in the application of norms to particular cases and controversies, it is plain that such applications in international politics must be sought in a wider range of arenas than judicial fora. The international incident takes a critical event as a prism through which the reactions of elites to particular behavior may be examined and assessed as an indication of their views of the law." So today I'm going to start with a brief overview of the facts. Then I'm going to turn to an elaboration of the legal norms at stake and violated in this episode. Then I'm going to examine the theme of international law's relevance from two perspectives. First, I'm going to explore whether the law is relevant insofar as there are or can be consequences for violations. Is the law existing on paper, or do states have ways to enforce it? Then I'll turn to the implications of this episode for the future of international law. Do the actions of states and other actors thus far have any broader lessons for whether international law's rules actually affect or govern state behavior? Finally, I should add that I will stay for the most part away from the Kremlinology of Saudi Arabia's internal politics, who is up and who is down, not only because it's beyond my expertise, but because those intricacies are not really central to my analysis today. I also want to confess that I'm not going to be using the PowerPoint very much because I'm not very good at it, and we don't use it very much at my law school. So let's start with the facts. Jamal Khashoggi entered the Saudi consulate at 1 p.m. on October the 2nd of last year. Turkey's government has released information showing that a group of 15 Saudi intelligence agents entered the country at 3 a.m. the same day and arrived at the consulate shortly before Khashoggi. According to recordings from inside the embassy taken by the Turkish government, that group strangled Khashoggi shortly after he arrived, dismembered his body, left the consulate and disposed of his body somewhere around Istanbul, and then flew back to Saudi Arabia the same day or the next day. After the disappearance became public knowledge, another team was sent from Saudi Arabia to investigate, but its mission seems to have been to remove as much evidence from the consulate as possible. Saudi Arabia allowed Turkish police to enter the consulate only 2 weeks later. And after weeks of denials on October 19th, Saudi Arabia admitted that Khashoggi had been killed, identifying the deputy intelligence chief, Ahmed al-Asiri, as the responsible commander and sacking him. On October 18th, Turkey announced that it will seek the extradition of 18 suspects from Saudi Arabia, but Saudi Arabia replied that it will prosecute any suspects domestically. Thus, on November 15th, the Saudi chief prosecutor announced charges against 11 men and promised to seek the death penalty for 5 of them. It later ruled out extraditing any of them to Turkey and has begun secret proceedings against them. As all of this was unfolding, various states reacted to the news, including through imposing sanctions on Saudi Arabia, as I will discuss more below. So let's talk about the law. From the perspective of both law and morality, the assassination of Jamal Khashoggi is quite simply a murder, politically motivated, meticulously planned, and gruesomely carried out. It is also a forced disappearance, for the location of his body remains unknown, thereby inflicting that additional crime on the family of denying them a body to see and to bury. From the perspective of international law, however, this crime is a serious violation of 3 major rules of the international system. Indeed, one can refer to these norms as constitutive norms in that they are foundational to the system itself. They are not Western norms, not imposed by the North on the South during or after colonialism. They are rather central norms defined in widely ratified treaties and customary international law. And just as important, 2 of these 3 norms are not even about the human rights of Jamal Khashoggi. The first norm is international law's ban on a state executing its laws or policies on the territory of another state without the latter's consent. International lawyers call this the ban on extraterritorial enforcement, and it's a rule that comes from customary international law's rules on jurisdiction. States are allowed to make laws governing some conduct beyond their borders, for instance by their own nationals, and they can use their own courts to adjudicate matters taking place abroad. But they can't enforce their laws or policies on another state's territory without the permission of the other state. This rule is related to international law's ban on intervention in the internal affairs of other states. While states and scholars don't quite agree on how far this ban goes, for instance, whether it covers electoral aid to opposition groups, extraterritorial enforcement clearly constitutes illegal intervention because of its blatantly coercive nature. And this ban is also within the penumbra of international law's most important rule, the ban on the use of force in Article 2.4 of the UN Charter. States generally respect this norm, notably when they cooperate on transnational law enforcement through, for instance, extradition arrangements. The last half of the century has witnessed some pretty flagrant violations, but for international lawyers at least, if states respond to those violations and the violator receives some sanctions, then the norm is still being enforced and reinforced. No legal system expects perfect compliance ex ante or perfect enforcement ex post. So several examples of responses to violations deserve mention. When Israel's Mossad killed a waiter in Lillehammer, Norway in 1973 after mistaking him for one of the plotters of the 1972 Munich Olympic massacre, the agency's operations in Europe came under intense scrutiny, and Israel eventually paid compensation to his family 2 decades later. When the Chilean junta organized the assassination of Chile's former ambassador, Orlando Letelier, in Washington in 1976, just outside the offices of the American Society of International Law in Sheridan Circle, the murder outraged the US government far more than the junta's executions and disappearances of thousands of political opponents ever did. The United States pursued the matter until the officials who had ordered the hit were prosecuted in US courts. Iranian agents have also been prosecuted for extraterritorial murders, including France's prosecution of one of the killers of Shahpur Bakhtiar, the Shah's last prime minister, who was murdered outside Paris in 1991. The British anger at the murder of Alexander Litvinenko in 2006 damaged relations between Russia and the UK, and the Kremlin's attempted assassination of Sergei Skripal and his daughter last year brought the relationship to a low point. Still, the norm is not always enforced. Israel and Argentina patched things up only a few months after the kidnapping by Israel of Nazi henchman Adolf Eichmann in 1960. The United States and Mexico moved on quite quickly from the US kidnapping of Humberto Alvarez Machin, suspected of complicity in the murder of a US drug enforcement agent in Mexico in 1990. Some of the Mossad's assassinations have taken place in countries without the ability or interest in retaliating against Israel or arresting its agents. Most recently in the 2010 killing of a Hamas leader in an Abu Dhabi hotel. In 1978, at the height of the Cold War, Bulgaria killed the dissident Georgy Markov while he waited for a bus on Waterloo Bridge in London, and nobody was ever caught. So that's the first rule. The second rule is a rule of diplomatic law reflected in the widely ratified 1961 Vienna Convention on Diplomatic Relations and the 1963 Vienna Convention on Consular Relations. So let's talk about the Consular Convention because this took place in a consulate rather than in an embassy. Under Article 5, and I hope it's at least readable for you, it's barely, I can barely see it on the TV back there, but I'll read it anyway. The first listed function of a consulate is protecting in the receiving state the interests of the sending state and of its nationals, both individuals and body corporate, within the limits prescribed by international law. And the fifth function is helping and assisting nationals. Article 55 states that consular officials must respect the laws and regulations of the host state. It doesn't take an international lawyer to see that Saudi Arabia violated these provisions. And to facilitate these responsibilities, embassies and consulates are inviolable. They cannot be entered without the permission of the head of the mission, and the diplomats are considered immune from the jurisdiction of the courts of the host state, at least for their official acts. This rule, too, is generally respected, although, to be frank, host states tolerate some flexibility when it comes to diplomats carrying out their functions, notably with respect to espionage. But when diplomats really abuse their positions, the norm has been enforced. When in 1984, a gunman in Libya's embassy in London killed a policewoman monitoring a demonstration outside the embassy, UK-Libyan relations reached a nadir and were only revived 15 years after, following an apology and compensation from Libya. When a Georgian diplomat killed a Maryland teenager in a car crash in 1997, the US State Department pressured Georgia to waive the diplomat's immunity, after which he was arrested, pleaded guilty, and went to prison. In comparison, the murder of Khashoggi took place inside the consulate and involved an element of treachery not seen in those two episodes. One thing, however, that states don't do to respond to violations of host country law by diplomats is to enter the diplomatic premises without permission. So Turkey sought permission from Saudi Arabia before sending its investigators into the Saudi consulate, even though it knew that Saudi Arabia was scrubbing the consulate. The UK has refused to extricate Julian Assange from the Ecuadorian embassy in London. The Chinese government tolerated dissident Fang Lizhi's temporary refuge in the US embassy in 1989 and 1990. And the US military waited outside the papal embassy in Panama City in 1989 for the surrender of dictator Manuel Noriega. Iran's seizure of the US embassy in 1979 stands as the only major example of an intrusion by the host state, and the country's international reputation plunged as a result. International law actually bans any breach of immunity by the host state, even in response to a breach of diplomatic rules by the sending state, for fear that it will undercut immunity generally, which all states regard as essential to the functioning of diplomacy. So both of these rules of international law, the ban on extraterritorial enforcement and the requirement that mission personnel carry out only official functions and comply with host country law, both of these rules represent a bargain that states have an interest in keeping. Keep your hitmen off my territory, and I'll keep mine off of yours. Use your embassies and consulates for diplomatic purposes and not to break the law, and we'll leave them alone. Each rule provides security to states, both that they need not worry about foreign states committing crimes on their soil, including those that might hurt their own citizens, and that diplomacy will function even when the sending state and the host state have tense relations. So we turn to the third rule. That's, of course, in the law of human rights. It is the ban on summary executions, central to the right to life, spelled out in the International Covenant on Civil and Political Rights. States are not allowed to kill people outside of judicial processes, their own nationals or anyone else. The death penalty is not banned under the ICCPR, but it's limited to grave offenses. The ICCPR doesn't address killing in wartime, where the laws of war allow states to kill combatants, but that surely does not apply here. Now, the international lawyers out there may field two objections to my invocation of the ICCPR. First, Saudi Arabia is one of 19 states, including Singapore and Malaysia, that is not a party to the International Covenant on Civil and Political Rights. True enough, but Article 6 is so central to human rights that most states would say it's entered the realm of customary law binding on all states. Even Saudi Arabia did not say it had a right to kill Jamal Khashoggi by virtue of being a non-party to the ICCPR. Second, lawyers would note that the act took place outside Saudi Arabia. The ICCPR requires states to carry out the obligations to protect the right to life to persons within its territory and subject to its jurisdiction, a phrase that most states interpret to mean that a state must guarantee rights to persons within their territory, and they must also guarantee those rights to persons within their jurisdiction. In this case, once Jamal Khashoggi stepped into the inviolable Saudi consulate in Istanbul, he was under Saudi jurisdiction and thus protected by the ICCPR. So 3 norms, 3 distinct violations. Turkey is in essence the key victim of the first 2 violations, and Jamal Khashoggi and his family are the victims of the 3rd violation. So let me turn now to accountability. The first issue regarding relevance, whether there's a possibility of accountability for these violations. Well, when we speak about accountability of those who killed Jamal Khashoggi, we are generally speaking not about revenge or some form of summary justice against the killers, but about working through channels that international law itself has established for addressing violations of the rules. The relevance of international law to this dispute depends, however, on whether those mechanisms actually offer the prospect of accountability or whether, on the other hand, they're simply empty boxes that exist in law books but are not actually used. In answering the question of the relevance of international law and the efficacy of the accountability mechanisms, we need to distinguish between mechanisms for holding the state accountable and for holding individuals accountable. For the former, international law operates in a mostly horizontal way, where violations, if they are addressed by other states. And here the results are, as of today, quite mixed. On the one hand, numerous governments have condemned the killing and called on Saudi Arabia to punish the perpetrators. But in terms of sanctions, little has happened. In November, Germany, Finland, and Denmark agreed to suspend arms sales to Saudi Arabia. The US Senate voted for a similar ban, but its resolution lacks the force of law. The key arms suppliers to Saudi Arabia, the US, the UK, and Finland, and France, have not suspended arms sales, and there seems little prospect for now that they will do so. Now, international law does have mechanisms for vertical enforcement in the sense of decisions by international or supranational organizations aimed at sanctioning non-compliance. But here, alas, the results are non-existent. The murder has not been discussed in the UN Security Council, the UN General Assembly, or the UN Human Rights Council. One special rapporteur of the Human Rights Council, the one on summary executions, is conducting a preliminary investigation with the hope that a political organ may set up a formal investigation. The same forces limiting interstate enforcement have resulted in almost no action in the United Nations. Yet we are witnessing what I would call private forms of accountability of the Saudi state. Universities and museums in the US are pulling back on exchange programs or turning down Saudi money. A group of US companies, including JP Morgan, the New York Times, CNN, the Financial Times, as well as the World Bank and the IMF, pulled out of co-sponsorship of the Kingdom's Future Investment Initiative conference in October. A number of other companies or investors, including Richard Branson, have announced withdrawal from pending deals with Saudi Arabia. Shareholders in publicly traded companies are likely to demand more. The story is not over yet. So is accountability of individuals any more likely? Now, some states have shown a willingness to act in terms of what I would call non-judicial enforcement. Thus, the United States, Canada, Germany, France, and other states have barred travel of some of those suspected of ordering or carrying out the killing. One of these covers the entire 26-nation Schengen zone. The US utilized legal authorities under the so-called Global Magnitsky Act to impose asset freezes and transaction bans on 17 named individuals. So clearly some individuals will be feeling the pain. No more visits to New York or Paris or London, probably not opportunities for their kids to be educated there either. These include some senior Saudi officials like Saud al-Qahtani, a senior advisor to Prince Mohammed bin Salman. Now, although the CIA has apparently concluded that MBS ordered the killings, he is not on anyone's sanctions list. As for judicial accountability, international law does require states to provide remedies for violations of human rights, including through criminal trials. But the Saudi trial is a black box. In a state not known for due process rights for defendants, it seems like a political trial. It's not even a show trial because it's not public. There will surely be some convictions and maybe some executions to eliminate those who can talk, but the trial already fails the basic international law standards for due process. Turkey, which has access to significant evidence, can only try the suspects, who will not have immunity, if Saudi Arabia hands them over, which seems very unlikely. And as for the International Criminal Court, it cannot take the case for too many reasons. A single murder during peacetime is not a crime against humanity within the court's jurisdiction. Neither Turkey nor Saudi Arabia are parties to the ICC statute. And the Security Council, which has the power to refer any case to the ICC, will not do so due to a likely veto from at least one permanent member, if not more. This state of affairs leaves a very mixed message regarding the enforcement of the three key rules. States are willing to sanction individual Saudi agents, but judicial accountability of individuals is unlikely in the near future. States are not, for the most part, holding the Saudi state accountable. Private enforcement seems to be happening, but frankly, it may be dwarfed by all the public and private investment and trade that is proceeding with Saudi Arabia as if nothing happened. On the other hand, it certainly does seem to be the case that Saudi Arabia's reputation and foreign policy have been harmed in a way that has yet to play out. States' tolerance of its support for the government of Yemen suffered a dramatic drop after the killing. The image of the prince as a great reformer and enabler of women's rights is under serious stress. Pressures will mount on governments not to invite him or leading officials to various events. And I believe some of this new animosity towards Saudi Arabia may play itself out in terms of its embargo with Qatar, perhaps finally causing the Saudis to release their grip on their neighbor. So the results thus far represent an interesting twist on what I regard as a general feature of the enforcement of international law against states versus its enforcement against individuals. Namely, that normally states are much more willing to respond against a state for violations, and a state is much more willing to accept the consequences of its violation than they are to go after individuals or for individuals to accept responsibility. Let me explain what I mean through one of my favorite examples, although an equally sad one. It's the Rainbow Warrior affair from the mid-1980s. In July 1985, French agents bombed a Greenpeace ship in Wellington Harbor, killing a Dutch photographer in an act that, like the Khashoggi murder, was a flagrant violation of international law's rules on extraterritorial enforcement, as well as human rights. When New Zealand and other states vociferously protested the bombing, France eventually, as a state, took responsibility and apologized for the affair, paid damages to the family of the photographer killed in the blast, and paid Greenpeace for the loss of the ship. But with respect to individual accountability, when the UN Secretary General, acting as a mediator in the dispute, recommended that the two responsible French agents be confined to a prison in French Polynesia for 3 years, France removed the two officers before the end of their sentence without New Zealand's approval. Although France later paid New Zealand $2 million in damages for this violation. In countless other situations, states have been sanctioned or blamed for various serious violations of international law, from uses of force to human rights violations to environmental harm, while the individual agents responsible for implementing the acts are never held to account. In the Khashoggi case, however, this pattern is more complicated. At first glance, it seems to be the reverse of Rainbow Warrior. State agents face travel and financial sanctions, while the state itself is subject only to modest sanctions from other states, and none that seem to be really biting at this stage. But when looked at more deeply, it may represent yet another reinforcement of the Rainbow Warrior paradigm. For the state is feeling some pressure in terms of private sanctions and the clear reputational effects that I mentioned. And if, as Western intelligence agencies seem to think, the Saudi Crown Prince did indeed order this killing, then his impunity reinforces the difficulty of holding individuals accountable even for the most serious international law violations. For those frustrated with the lack of significant accountability to date, the Khashoggi assassination serves as yet another example of the need to think in the long term about such possibilities. I know this from experience in the case of Sri Lanka, where the last phases of its civil war resulted in very large numbers of civilian casualties in the Tamil areas in the northeast. The government at first denied that any civilians were killed. But the UN Secretary General, after visiting Sri Lanka at the end of the war, managed to get the country's president to agree in a joint communique to address the grievances of individuals. The Secretary General took this rather bland commitment by the president of Sri Lanka and used it to create, on his own authority, a panel of experts on which I served to examine the allegations of misconduct and war crimes by the government and the Tamil Tigers during the final stages of the war and give advice to the government on accountability. Our report to the UN made a realistic and I think fairly modest recommendation with respect to accountability: that the Sri Lankan government cease its policy of denialism and initiate a fair investigation of the allegations, or failing that the UN do so through an independent commission of inquiry. But the UN Secretary General merely acknowledged our report. Rather than endorsing the conclusions, he simply passed it to the President of the Human Rights Council for action. Only after intensive lobbying by a small number of states, led by the US, did the Council pass a resolution in 2012, the following year, somewhat critical of Sri Lanka's lack of investigations. And only 2 years later, in 2014, did the Council eventually ask the Office of the High Commissioner for Human Rights to look into the facts of the final stages of the war, although its report was not that of a full-fledged commission of inquiry. Yet this set of very small steps did send a message of isolation to Sri Lanka and its citizens. The following year, in 2015, the government lost the general election for multiple reasons, replaced by a new government that is somewhat more committed to engaging with the accountability question. On the other hand, even now, 10 years after the end of the conflict, the government still has not begun a serious investigation. To take a second example, in the case of the Khmer Rouge, whose 3-year rule killed some 1.5 million Cambodians, the 1991 peace accord left accountability of the Khmer Rouge up to a future post-election government. When that government did nothing on its own to investigate, the UN Special Representative in Cambodia persuaded the government to ask the UN for assistance on the issue. The General Assembly took up the UN-engineered request in 1997 by asking the Secretary General to create a group of experts to make recommendations on accountability. a panel on which I also served. Our 1991 report called for the creation of a new international court to try Khmer Rouge leaders, given the lack of credibility and independence of the Cambodian judiciary. Yet the SG decided to endorse a different, less expensive plan for a hybrid UN domestic tribunal, an idea that our panel had rejected because we believed the Cambodian government would seek to undermine it. 4 years later, in 2003, the UN and Cambodia agreed on a hybrid tribunal, but since then, it has managed to try only 3 people and advance the cases of 3 others, falling prey to the very interference that our panel had predicted. Justice was very long delayed and only very partially achieved. So the lesson of these 2 episodes is double-edged in terms of its implications for the Khashoggi murder. Accountability will need to proceed in slow steps to get anywhere, and it may not get satisfactory results. First, an unbiased accounting of the facts will be needed. Ideally, the UN should carry this out, but Saudi Arabia and its friends have prevented the UN's political organs from establishing such an inquiry, as the UN did in the case of the assassinations of Benazir Bhutto and Rafiq Hariri. Legally, the Secretary General can carry out an investigation without such a mandate. The easiest route is if he received a direct request from either Saudi Arabia or Turkey, but a request from the former is out of the question, and for reasons not yet clear, Turkey has not yet asked for an international inquiry. It may be that Turkey is afraid that a UN inquiry will take the narrative out of its control. But in my view, even without a request of a political organ or Turkey, the Secretary General has the legal authority to create a commission of inquiry. And I know that some delegations in New York are hoping that he will do just that. The Secretary General can defend this move to member states as part of his mandate regarding peace and security. For the murder in Istanbul is an assault on the key norms protecting states as much as it is an assault on the norms of human rights. If an impartial investigation can be undertaken and it can reveal who was behind the murder, states will feel even more of an incentive or pressure to impose sanctions on Saudi Arabia or individual Saudis. Even Saudi Arabia's rulers may begin to feel some pressure, although it's very hard to say what form of accountability might be meted out to them in the end. Let me turn now to the last part of my talk about the implications for international law. One of my great interests as an international lawyer is ascertaining the influence of international law in the decisions of global actors. While some international lawyers talk about the rule of law and equate that with the decisions of international courts, I am much more concerned about the role of law outside of judicial venues. I regard this project as necessitated by the simple reality that most international disputes are still addressed and resolved by states outside of international courts, where no judge tells them the legally correct answer, and there is no obligation to comply with a court judgment. Speaking very personally, I suspect this focus of inquiry stems from my own service at the beginning of my legal career as a lawyer for the State Department, and then later as a member of these 2 panels of experts. Outside of courts, states, the UN, and other actors take international law into account not because they are international judges who must act only according to law, or because they are parties to a judicial case bound to follow a ruling, but because they see it in their interest, or even as part of their identity, to comply with international law, except when they don't. Understanding when and how the law affects decisions in these contexts is immensely challenging, but also far more relevant for a descriptive agenda of understanding how the law matters and a prescriptive agenda of seeking to make international law more relevant. So in that light, I want to move beyond analyzing the legal universe surrounding the episode to understanding how this episode affects the legal universe. What does it show about the relevance of international law? And I want to make 5 observations. First, international law represents a framing device for understanding and speaking about the Khashoggi murder. Former UN Secretary General Boutros Boutros-Ghali once called it a common language in that it enables us to analyze this event from a certain agreed standpoint. The rules in this case are not in doubt or in transition, unlike other areas of international law. There's no such thing as Asian values when it comes to diplomatic immunity or even summary executions. States of many different political persuasions can frame their reactions to the murder in a way that creates a discursive practice open to many participants. The idea of international law as a process of communication is one that has been identified by scholars of both international law and international relations. States want to justify their actions as consistent with international law and condemn the actions of those they oppose as violations of international law. Second, Saudi Arabia's actions in this killing suggest that states still find incentives to violate. My margins were so good on the original one, something happened in the transatlantic move of my PowerPoint. Saudi Arabia's actions suggest that states still find incentives to violate the core rules, that they engage in calculations up front that at the time may make it seem like it's in their national interest to violate the rules, but turn out to be wrong. The pedigree of these rules, as well established and indeed constitutive of our interstate system, does not, in a word, make them self-enforcing. International lawyers and political scientists have developed many theories for why states comply with most international law rules. Let me just mention 6 of them. They're not on the slide, but we can talk about them later if you'd like. Sometimes, of course, states have an innate belief in the values and policies behind the law, as with many states' approaches to human rights law. Second, sometimes states internalize the obligations through their bureaucracies or respond to domestic constituencies, corporate or otherwise, to comply with the rules. Third, sometimes states want to avoid a reciprocal response by the state affected by their violation. Think of the rules protecting prisoners of war. We treat prisoners of war well so that our adversary will treat our prisoners well. Fourth, sometimes states adhere to rules because they want to avoid setting a precedent that another state, not the one immediately harmed by the violation, might use against their own interests. This is so-called diffuse reciprocity, and it explains, for instance, the adherence to diplomatic law. The UK, for instance, leaves Assange alone in the Ecuadorian embassy, not because it fears that if it removed him, Ecuador would take over the UK embassy in Quito, but because the UK does not want to set any precedent for any state to interpret diplomatic law to allow for entry into an embassy, because it regards that as destabilizing. Fifth, sometimes states fear an action in international court, as with international trade or investment law. And finally, as the constructivist stand of IR theory would have it, international law also defines the identities of states, so that advancement of certain international rules goes deeper than merely self-interest. But in the case of Saudi Arabia, none of these 6 paths for compliance seems to have been followed, even though the norms themselves are highly accepted. Perhaps the Saudi government thought nobody would ever tie them to the murder. Perhaps they thought it would all blow over. Either way, they seriously miscalculated both the intelligence capabilities of the Turkish authorities and the extent to which states would care about this triply egregious violation of international law. Third, although it's somewhat difficult to look behind state reactions, my sense is that the continued international outcry of many governments and private actors over Khashoggi's killing, an outcry the Saudi government probably did not expect, stems from a violation of the first 2 norms as much as, and probably more than, a violation of the third. To be blunt, states kill political opponents and journalists with some regularity, even if they hide some of it by saying the police used too much force or that the victim was in ill health. States do not, however, do this frequently on other states' territory, and never, to my knowledge, in one of their embassies. In that sense, Khashoggi's murder is a singular event in international law, and it has elicited a singular response of outrage. These reactions highlight a lag in responses to systemic violations of international human rights or humanitarian law compared to rules of diplomatic law. Mass atrocities in Congo, South Sudan, Yemen, or Myanmar should garner greater outrage than the death of one journalist. But sometimes it's only when a state breaks the rules meant to protect other states, not those meant to protect other people, that the international community sits up and notices. At the same time, it also seems clear that many of the reactions by the private actors, the individuals, universities, event sponsors, are very much driven by the violation of human rights, and particularly the treachery accompanying this particular murder. Fourth, the episode for me highlights the empirical complexity of judging state reactions to violations of international law. and thus indirectly judging whether international law norms are actually being enforced. We know the reactions of a small number of states because they have been very public about it. Others have been extremely circumspect. Take China's official reaction from a foreign ministry spokesman on October the 25th. Quote, "The death of Saudi Arabian journalist Jamal Khashoggi has aroused widespread concern from the international community. We have noted that the Saudi Arabian side has announced the initial result of the investigation and taken steps to find out the truth. We have also taken note of the statements by Turkey and other parties on this issue. It is a tragic incident. We hope that this case will be dealt with properly. We will continue to follow it." Unquote. What does that mean? And of course, many states, indeed most states, have said nothing at all. All this silence could be interpreted as a lack of protest and thus a decision not to enforce the rules. But if privately Saudi Arabia is hearing opposition as well as encountering new obstacles to its foreign policy goals, then the verdict would be somewhat different. Now, certainly a number of states are taking their cue from the United States, which has been reluctant to criticize the Saudi state and has effectively accepted the Saudi line that this was the work of rogue individuals. I should say the US president, not the US intelligence community. So it is surely the case that some states exert outsized influence in the enforcement process of international law. But we still need to know what is happening more broadly, and it's very hard to when states don't speak publicly with their views about these matters. Fifth, the role played by non-state actors in the accountability process is essential to understanding the enforcement or lack thereof of international law. As I mentioned earlier, international lawyers, unlike some of their domestic counterparts, are quite comfortable thinking about non-hierarchical modes of enforcement of the law, simply because we have no authoritative compulsory international court and law enforcement arm. International lawyers are also open to thinking about the influence of private actors in the making of international law, whether in developing technical standards for aircraft and telecommunications, or how a trade agreement or a bilateral investment treaty will be worded. But we are only just now beginning to think about non-state actors in the enforcement process of international law. But their involvement is nothing new. It goes back as far as private boycotts of South Africa and demands by consumers for dolphin-safe tuna. What is happening here seems far broader, as a wide range of groups with a lot of money seem to be willing to use it to make a point about the Khashoggi assassination. And Khashoggi's case remains in the headlines due to the persistence of one of these private actors, the Washington Post, for whom he was an opinion writer. Now, whether international lawyers need a theory for this involvement, I will leave for another day. But advocates certainly know that in order to get the attention of states to take responsibility for their actions, private money and bad publicity from non-state actors can speak just as loudly as sanctions by governments. So in conclusion, and to return to the framework of international incidents that I mentioned in the beginning of my lecture, surely the Khashoggi murder is the sort of incident that deserves study, for it shows the durability and the limits of key norms of international law and mechanisms for accountability. The reactions of states and non-state actors to date validate neither the apologists for international law, who defend the rules and stress their binding character, nor the denialists of international law, who insist that the law is and should be irrelevant for state decision-making. There are no simple lessons to draw here. But to end, we international lawyers must not forget the moral issues at the core of the incident. In the case of the murder of Jamal Khashoggi, the three rules violated by Saudi Arabia all have a strong moral grounding. The first two rules in preventing interstate conflict, and the third rule in promoting human dignity. They are, in that sense, not merely justified rules, but just rules of international law. But to make sure these just rules are not, so to speak, just rules, there must be consequences for their violation. It is not merely a matter of legal requirements, but it is at its heart a moral demand. Thank you very much.
Thank Thank you, Professor Rattner. I have a few questions of my own for you before we open it to the floor. I guess my first question is: has there been any reaction to the op-ed you wrote in the Washington Post calling on the UN Secretary General to convene a UN-led investigation? I know you mentioned it, but I'm wondering if you've got any more comments on that.
I mean, I was contacted by, so I mentioned in my talk, the UN Special Rapporteur on Summary Executions. Her name is Agnès Callamard. She's a French national, and she's doing this as part of her mandate to look into summary executions. She's doing a report to the UN Human Rights Council on her own initiative. And she and I talked last week about this, and she had read my piece. So and she said there is certainly interest in the Secretary General doing this, but it's really, in a sense, his call as to whether he feels he has the political backing of states to do something absent a request from Turkey. If Turkey were to ask, that will make it I think, politically sufficient for him to go ahead and do something. But this is one of the black boxes of this, is no one is quite certain how Turkey's position on an international inquiry is going to evolve.
Okay. What about the UN General Assembly? You mentioned that there's been no discussion there.
There hasn't been.
Is that because of the Trump factor?
No, I don't think it's the Trump factor. I think it's. I think that you have, a lot of states that are friends with Saudi Arabia, and you need to have a certain critical mass to get a discussion going, and at this point, it hasn't been enough. The G77 sticks together on certain things. Saudi Arabia is a major leader. The G77 is the group of sort of developing / formerly non-aligned states. It's more than 77 countries, but it's still called the Group of 77. And there are certain states that are very, very influential in the G77, and Saudi Arabia has always been one of them. So now things could change. If you have some states that decide they want to move forward, there certainly could be votes in the GA to create a commission. But there's a lot of heavy work that has to be done for that to happen.
And what about Congress? There's some discussions there.
Well, Congress can't create. I mean,
on sanctions. Or military.
Again, there was a Senate vote on sanctions. Again, even if both houses of Congress, as the U.S. is about to discover with this emergency wall funding, even if both houses of Congress were to, make it part of U.S. policy to have a commission of inquiry or to have more sanctions in Saudi Arabia, if the president vetoes the law, then you only can get it passed if there's a 2/3 vote in both houses of Congress, which is very, very hard to get.
Okay. And one final question. Sorry, I'm hogging the floor. Does it make any difference that the chief suspect in this case is more or less a sovereign? He is a king in waiting, and it's different when you have an agent or an agency of the state. Saudi Arabia is, it's different to other countries. Do you have the question of sovereign immunity there, or?
So, I mean, there's a question of, there's a very narrow question in there, which is, does a head of state have immunity from the jurisdiction of other courts? And the short answer is basically yes. It would be very difficult for another state to try a head of state, even for an act like this. He doesn't have immunity in front of the International Criminal Court, but again, as I said, that's not something that's going to happen. But the broader part of that question, as I interpret it, is accountability more difficult? If there's a view that, in fact, he ordered the killing. Now, I don't know whether that makes him the chief suspect. I mean, again, we don't know. Order, acquiesce. I didn't. The views of the intelligence agencies have not been made public. They're all just reported through leaks. But certainly, when it gets that personal, and I think that makes accountability much harder, and it causes, it will cause him to have certain ways of wanting to treat this issue, and it will cause other states as well. He's certainly not the first head of state to order the murder of an opponent, but I think the first to order it to be done in an embassy.
Yeah, thanks. Okay, the floor is open. If you have a question, could you please say, give your name and if you know where you're from. And the lady in front of me is the first.
Thank you. I have a related question. Thank you, first of all, for your talk. My name is Maddie. I'm a third-year literature student at Yale and US down the road.
Great.
So you mentioned that states prefer to diffuse accountability or punishment across the state as opposed to target the individuals that could be held responsible.
Right.
Why?
So my point is, as you correctly surmised, is that generally the enforcement of international law is done against the state because the reactions, because the state is generally the target that the sort of victims and other aggrieved actors are willing to go against more than the individuals. And you're asking, why does that happen? And I think that it happens, honestly, I think there is this idea that international incidents are even more delicate and more impervious to solutions when it starts getting personal. So, you know, so I'll give you another example, and maybe this will lead to an answer to your question. You know, the U.S. has, over the course of the Iraq War and the war in Afghanistan, paid reparations to people whom it's bombed by mistake. It's not so public, but they do this. And you know, sometimes it's as crass as, you know, an officer showing up with a suitcase full of dollars, but sometimes it's, you know, actually some kind of meaningful, you know, amount of money to a village or a family. But what drives the U.S. crazy is the idea that the International Criminal Court could possibly try an American service member for war crimes, for dropping the bomb either intentionally or accidentally. And I think states are just nervous. I think there's this idea that if we go after individuals, our officials are going to go into jail, and I could be at risk of jail. And so everybody's sort of safer if we just go after states. In other words, if something happens to me, I'm going to go against the government rather than the individuals. And so if I do something that bothers you, you're going to go after my state, but not after me. So in a way, it's a kind of mutual way of ensuring that no individuals go to jail for egregious violations of international law, and to preserve accountability to the state. Now, the more charitable way of looking at it is that states actually have the potential, because they're well-resourced, they have the potential to pay reparations for harms in a way that individuals can't. So in that sense, it may be good to go after the state, because if the state admits responsibility, it could pay reparations. Whereas, you know, the average agent, I mean, MBS accepted, doesn't usually have the money to pay out, you know, millions of dollars of reparations. So there's both a kind of mutual back-scratching society element to it, but there's also this idea that it provides an opportunity for reparations if the state is held accountable.
Has anyone got any other questions?
Please, I'd like to hear your reactions and your questions and you know, your opinions.
Hello, so I'm Sean. I'm from NUS Law. So as a follow-up to that question, so to what extent does such a response dissociate moral responsibility for such crimes away from the individuals? And on a related note, how far should we move away from such a statist conception of international law towards probably more individualized responses to such crimes?
Sure. Well, I mean, one thing I would say is that there's nothing inherently contradictory of having both forms of accountability. You know, if you want to enforce the rules and create deterrence for future violations, the best way is to have accountability at different levels. The state paying damages, and individuals, if they've really had a criminal intent, you know, going to jail, but if not going to jail, at least, let's say, facing loss of office or loss of the ability to travel or frozen assets. So there's some meaningful accountability. So I think you really need to have both. I think there have been very small but significant movements in international law since the Nuremberg trials after World War II to recognize that individuals should be held accountable in addition to states. We've had, trials of Yugoslav war criminals and Rwandan genocidaires and others that have taken place over the last 20 or 30 years. We now have the International Criminal Court, but I don't think you can really think about it as an either-or thing. I think that if it's too hard to go after the individuals, if the ICC isn't available, you should focus on going after states. And if for some reason you can go after both, you should try to go after both. So I think we are moving towards it, but at the same time, and just to sort of put another gloss on this, you also have to think about due process, which is that if you're going to sort of hold individuals accountable, you have to give them a fair trial. You can't just throw somebody in jail because you think they're guilty. With the state, if you've got sort of enough evidence, you don't really have to know whether they intended to do it, whether it was malicious, whether there was a sort of evil mens rea. If the state agents did it, then the state is responsible. But to hold an individual criminally culpable, you've got to show that there's a mens rea, that they actually meant to do the act. And you've got to give them a fair trial. And so in that case, it could be a situation where the state is accountable, but you simply don't have the evidence to hold an individuals responsible, and it wouldn't be fair to throw them in prison based on the evidence that you do have.
Quickly on the issue of evidence, the random question. I mean, can U.S. lawyers sequester or request information from the CIA? Because they have this supposed tape. Or
well, I think actually it's not clear whether whether the Turkish government actually gave copies of the tapes to anybody, as opposed to playing it for a handful of officials. It's my understanding, actually from Agnes, that they did not give out any copies, and the reason they did not is because they don't want people to find out how they got the recordings. Whether they got them through a bug in the embassy, or whether it was listening in on wires, or whether it was some kind of external device picking up what was done in the embassy. And as for your first point is, no, there are huge carve-outs of the Freedom of Information Act when it comes to intelligence. So it's impossible for lawyers to get these things. Now, the CIA has been known over the years to declassify things, but this is far too sensitive and too close in real time for them to do that.
Okay.
Yeah.
Any more questions? Yep. A gentleman here at the front.
Awesome. Hi, my name's Jacob. I'm an exchange student from the University of British Columbia in Vancouver. And my question is a bit more related to the current US president. Do you think that his presidency has kind of emboldened this behavior, or that this would have happened with any president in power? This could happen again with the next president or the one before?
Well, I mean, even though I'm speaking at the Middle East Institute, I am only as good on that question as the articles by experts that I read. My own view is that the combination of the arrest and /torture /imprisonment of the members of certain members of the ruling class, the increase in support for the government of Yemen, the embargo on Qatar, and this are all linked to a sense that there are not costs to these actions from the Saudis' leading ally. And had there been a president in Washington, there was a different president in Washington before, right? And had there been a different president in Washington, several of these things, either wouldn't have happened or they would have spun out quite differently. That's my personal view. I find the commentators I read about that quite convincing. That and this is not so much the policy of the Secretary of State, but it's a very personal reading that comes from a relationship between the two heads of state and a realization, I think, by the Saudi Crown Prince that he has a friend in the White House. And so I guess the answer to your question is yes, I do think there's a connection.
Thank you very much.
We have time for another question if anyone has one.
What has since been done with the proposal from the panel that you sat on in 1991 that proposed a new ICC or a new structure for the ICC, if anything?
So I was on two panels. One was about Cambodia and one was about Sri Lanka. So which one are you referring to, or was there another panel that I was on that I missed?
I think the one that I was referring to that you mentioned was when the UN decided to go with a hybrid tribunal.
Right. Okay, that was Cambodia, right?
Yeah.
So so what happened was, as I say, we recommended what was called a full-fledged ad hoc tribunal created by the Security Council, funded by the United Nations, with UN-appointed judges. And there are two clear precedents for this. This is the UN, the International Criminal Tribunal for former Yugoslavia and the International Tribunal for Rwanda were both created through the Security Council, and they both tried, dozens of individuals and lots of people sitting in jail as a result of these trials. We thought that would be the best way to hold Khmer Rouge leaders who were still alive accountable in a fair way, was through an independent UN-created court with UN-appointed judges. The Secretary General, those courts are expensive, like $100 million a year. And you have to get the Security Council to create them. In the case of Cambodia, the Secretary General felt that the cost would have been very high. He was also worried that China and maybe Russia, as supporters of the Cambodian government, might veto a proposal in the Security Council. So instead, what he proposed was what's called a hybrid tribunal, which has UN-appointed judges and Cambodian judges. And to create such a tribunal, you don't need a vote of the Security Council, you just need an agreement between the Secretary General and the Cambodian government. So after 4 years of negotiations, they succeeded in creating that tribunal. And it's a mixed tribunal, it's called a hybrid tribunal. And so that was created in 2003, but as I said, in the 15 years since the tribunal has been in effect, it's only tried 3 people. And part of the reason it's only been able to try 3 people is because all along the way, the Cambodian prosecutors and the UN prosecutors have disagreed about issues. The Cambodian judges and the UN judges have disagreed about issues, about whom to indict, about how fast to move. And as a result of this, the tribunal has had a very sort of poor track record. So that's what happened. Does that answer your question? Yeah. Okay.
Was it also more expensive as a result?
No, it was cheaper. It was cheaper, actually, and it wasn't all funded by the UN. Some of it, quite a bit of it was funded by Japan, outside of part of it was funded by the UN, part of it was funded by individual countries. It did end up being quite a bit cheaper. For one thing, because it was based in Phnom Penh as opposed to being in The Hague. It had a much smaller staff, but the results are pretty unimpressive when you think about how long it's had to work.
Okay, you got a question? Yeah.
Hello, my name is Josephine Catan. I'm retired. Quick question: what happened to the ambassador in Turkey from the Saudi Arabian embassy?
You mean so he would have been the consul general, because the ambassador would be in Ankara. I believe that Saudi Arabia has recalled a number of people that were in the diplomatic staff. I don't know whether it recalled all of them. I think the worry was that Turkey would declare them to be what's called persona non grata, which is basically a way of saying if you don't get out of the country in X number of hours, we're going to take away your privilege. We're going to pretend you're not, we're going to treat you like you're not a diplomat anymore, and you could be arrested. And so I think because the Saudis knew that, that the Turks knew that there were senior people in the consulate who were responsible, they withdrew them. I might be wrong about just exactly whom they withdrew, but certainly some were recalled back to Riyadh.
One other question. Do you think Turkey followed international procedures with this incident, or do you think they failed?
Well, so there's two questions. I mean, they certainly followed international procedures in terms of not going into the embassy without the permission of the Saudi government. That's absolutely required under the Vienna Convention. You can't even go there if there's a fire without getting the permission of the embassy. I mean, there's some tiny exceptions. If the embassy is empty and there's a fire, then you can go in. But pretty much, you really need the permission. So I think they followed the book by waiting, even though they probably knew what was going on during those 2 weeks. There's two other angles to it. I mean, if they knew in real time what was happening, did they do enough? Should they have warned him what was happening? Very fair question. He is not their citizen. On the other hand, he was on their territory, and it certainly can be argued that under human rights law, the state has a duty to warn an individual if they have clear evidence that he's about to be murdered. Now, that's an interesting question of human rights law, but you could make that argument if, in fact, it were true that they knew about this in real time. And a third issue, when you ask, did they do it by the book, is the whole question of the surveillance. So this term inviolability that I had up on the slide, is the state allowed to actually bug an embassy? Well, technically speaking, it's not, except that this is a rule that is honored in the breach. Any state that has the capacity to do so bugs the embassies on its territory, and the embassies know this, and usually they have special rooms that they have their most sensitive meetings in, or they have these sensitive conversations outside of the building. So technically, some of these interceptions, if they were done through bugging the embassy, may well have been illegal on Turkey's part. And some people theorize, well, that's why they don't want to turn it over to an investigation, because they would be embarrassed by that. So there are a number of possible ways in which Turkey did not live up to international law, one being about the bugging, but I think the more interesting consequential question is whether it had a duty to Khashoggi that it failed to meet in terms of warning him.
And no sign of his body still?
No, nothing. Just pictures of forests on websites, but nothing. This is, and this actually is, to me, particularly mindless and cruel, because clearly the agents have this information. Revealing where there must be some view that revealing this would somehow implicate them, even though Saudi Arabia has said that they're already implicated. So who exactly is gaining from this uncertainty? This is very, very hard for me to figure out why we don't know this, why Saudi Arabia would not want to share this information at this point.
And on that sober note, I think we'll end. And if you can give a round of applause to Professor Rattner for his great talk. Thank you.